Maine has a moderately regulated breaking lease framework that has become more tenant protective in recent years, consistent with the state's overall direction on landlord-tenant law. The governing law is found in Maine's landlord-tenant statutes, Maine Revised Statutes, Title 14, Chapter 710, along with general contract principles and Portland's additional local protections. If you're a landlord or tenant in Maine, the state provides meaningful tenant protections while still recognizing landlords' right to recover legitimate damages. Let's start with the landlord's duty to mitigate damages. Maine law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is established through Maine case law and the state's general contract principles. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps: advertising, showing the property, and accepting a qualified replacement tenant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Maine's overall legal culture favors tenant protections, and courts evaluate the landlord's mitigation efforts with attention to whether the landlord acted promptly and reasonably. In Maine's tight rental markets, particularly Portland and the southern coast, landlords can typically re-rent relatively quickly, which limits the departing tenant's financial exposure. Early termination clauses are generally enforceable in Maine if they are reasonable. Maine's Unfair Trade Practices Act, Title V, Section 207, provides a basis for challenging lease provisions that are unfair or deceptive. An early termination fee that grossly exceeds the landlord's actual or anticipated damages could be challenged under this framework. A fee of 1 to 2 months' rent with reasonable notice is typical and generally enforceable. Maine courts evaluate the enforceability of early termination fees based on whether the amount represents a reasonable pre-estimate of damages. The fee cannot function as a penalty designed to prevent early termination. It must bear a reasonable relationship to the landlord's actual expected losses. In Portland's tight market where re-rental happens quickly, a 2-month fee may face more scrutiny than the same fee in a softer rural market where re-rental takes longer. Military members have the right to break a lease under the SCRA. Maine's military population is relatively limited. The former Brunswick Naval Air Station has been redeveloped and no longer generates military rental demand. The Portsmouth Naval Shipyard, technically in Kittery, Maine, generates some demand in the southern Maine area. The Maine National Guard has facilities throughout the state. Any service member renting in Maine has full SCRA protections. Maine has enacted protections for victims of domestic violence, sexual assault, and stalking that allow early lease termination under Maine Revised Statutes. Title 14, Section 6002 in A, a tenant who is a victim of domestic violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation can include a copy of a valid protection from abuse order, a copy of a court order related to the domestic violence or sexual assault, or a written statement from a law enforcement officer, healthcare provider, or qualified domestic violence or sexual assault advocate. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit must be returned according to standard rules, within 30 days if the landlord intends deductions, or within 21 days if no deductions apply. Maine's provision includes privacy protections. The landlord must keep the documentation confidential and cannot disclose the tenant's status as a victim. The landlord also cannot use the domestic violence termination as a basis for negative references or future rental denial. Tenants in Maine may break a lease if the landlord fails to maintain habitable conditions. Maine recognizes an implied warranty of habitability in residential leases. Under Title 14, Section 6021, the landlord has a duty to maintain the premises in a condition fit for human habitation, including compliance with applicable building and housing codes and maintenance of essential systems. If the landlord fails to address serious habitability issues after receiving proper written notice, the tenant has remedies that can include lease termination. The tenant must provide written notice identifying the specific deficiencies and allow a reasonable time for the landlord to make repairs. If the landlord fails to act, the tenant can terminate. Maine's Housing Code Enforcement provides an additional mechanism. Tenants can contact their local code enforcement officer or the Maine Department of Health and Human Services to report housing code violations. An official inspection and citation provides objective documentation supporting the tenant's right to terminate based on habitability. Maine also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off heat, failing to address dangerous conditions, changing locks, render the unit uninhabitable, the tenant can treat the lease as terminated. Maine's cold climate makes heating failures particularly urgent. A landlord who fails to restore heat during a Maine winter creates an immediate health emergency. Maine has a specific provision regarding the landlord's right to enter the property. Under Title 14, Section 6025, the landlord must provide at least 24 hours notice before entering except in emergencies. If the landlord repeatedly violates the notice requirement or enters without permission, this conduct can constitute a breach of the tenant's right to quiet enjoyment, potentially supporting a constructive eviction claim. Portland adds additional complexity to the breaking lease framework. Portland has enacted local tenant protections, including a fair chance housing ordinance that affects screening of replacement tenants and other provisions that may affect the breaking lease process. Portland's political environment is the most tenant protective in Maine, and landlords in Portland should treat the city's requirements as their compliance baseline. Portland's tenant advocacy community, including Pine Tree Legal Assistance and Maine Equal Justice, is active and well organized. Landlords in Portland who handle broken leases unfairly or who fail to mitigate can expect organized tenant advocacy in response. From a practical standpoint, Maine's rental market varies dramatically between the southern coast and the rest of the state. Portland is Maine's dominant rental market and the most expensive community in the state. When a tenant breaks a lease in Portland, the landlord can typically re-rent within 2 to 4 weeks, often faster during the spring and summer peak season. Portland's economy is driven by healthcare, higher education, tourism, a nationally recognized food scene, and a growing technology sector. Demand consistently exceeds supply, and broken leases in Portland usually result in minimal financial exposure for the departing tenant. The Greater Portland area, South Portland, Scarborough, Westbrook, Falmouth, extends Portland's tight market dynamics. Re-rental in these communities is generally quick. Lewiston-Auburn has a more affordable market. Lewiston's growing immigrant community, primarily Somali and African, has increased demand, but also added tenants who may break leases due to economic hardship or family relocation. Landlords should be realistic about collectability when pursuing claims against departing tenants with limited financial resources. Bangor has a moderate market driven by healthcare and the University of Maine in nearby Orono. Re-rental is moderate, 2 to 4 weeks for well-maintained units. Augusta, the state capital, has a small, stable market. The Mid-Coast and Down-East communities have seasonal dynamics. Bar Harbor's proximity to Acadia National Park creates seasonal workforce demand. A lease break during spring can be filled with incoming seasonal workers. Off-season breaks take longer. Northern Maine, Aroostook County communities like Presque Isle, Caribou, and Houlton has the softest markets in the state. Re-rental can take significantly longer. Landlords in northern Maine should structure their leases with realistic expectations about vacancy periods. One best practice for Maine landlords: calibrate your early termination fee to your specific market. In Portland, where you can re-rent in 2 weeks, a fee exceeding 1 month's rent may face challenge. In a rural area where re-rental takes 2 months, a 2-month fee is more defensible. The fee must reflect your realistic expected losses. Another best practice: begin re-rental efforts immediately when a tenant provides notice or when you discover abandonment. Maine's mitigation duty is clear, and the state's active tenant advocacy organizations mean that your mitigation efforts are likely to be scrutinized if a dispute arises. Document everything: listing dates, advertising channels, inquiries, showings, and when you accepted a replacement. A third best practice: have a standard process for handling domestic violence terminations under Section 6002A. Train your staff to accept qualifying documentation, process the termination within the required timeframe, return the deposit according to standard rules, and maintain strict confidentiality. Maine's tenant advocacy community monitors landlord practices, and fair handling of domestic violence terminations is both a legal requirement and a professional standard. Maine limits the security deposit to 2 months' rent. The landlord must return the deposit within 30 days if deductions apply, or within 21 days if no deductions apply. The landlord must provide an itemized statement of any deductions. If the landlord fails to comply, the landlord may be liable for double the amount wrongfully withheld plus attorney's fees. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Maine breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.